So if you're a landlord, or even a tenant, and you haven't been paying attention to what's been happening with rental laws going into 2026, I need you to stop whatever you're doing right now and watch this entire video. Because the rules of the game have changed significantly, and whether you own one rental property or 20, or whether you're renting an apartment and think none of this applies to you, it absolutely does. The legal landscape between landlords and tenants has shifted more in the past 2 years than it did in the previous decade. And most people on both sides of this have no idea. Now here's what frustrates me about this topic. You've got landlords operating like it's still 2019, using lease clauses that are no longer enforceable, running eviction processes that are going to get thrown out of court, and exposing themselves to massive financial liability, all because they didn't bother to update their knowledge. And on the flip side, you've got tenants who are being walked all over because they don't know what protections they actually have. Both sides are losing, and the only people winning are the attorneys cleaning up the mess afterward. So today I'm going to walk you through the most important updates to landlord-tenant law heading into 2026. Some of these are federal level shifts, some are state specific, and I'll flag those clearly. Some are brand new, some are updates to rules that already existed but have gotten significantly stricter. Either way, if you're involved in a rental property in any capacity, this is the video you need. Let's get into it. First, notice requirements for eviction have gotten longer and more complicated in most states. This is the one that's catching landlords off guard the most right now. The general expectation used to be that if a tenant didn't pay rent, you posted a 3-day notice, waited it out, and filed. That window has expanded in many states. We're seeing 5-day, 10-day, and even 30-day notice requirements now, depending on the reason for eviction and how long the tenant has been in the unit. And here's the critical part that most landlords miss. It's not just about the number of days anymore. It's about how you deliver that notice. Posting it on a door may no longer be sufficient in your jurisdiction. Some states now require certified mail. Some require both physical posting and mail. Some require email notification if an email address was provided in the lease. If you get the delivery method wrong, the entire eviction gets thrown out. You go back to square one. You lose weeks. You lose rent. And the tenant is still in your property. I've seen landlords make this mistake repeatedly, and it is completely avoidable if you just know the current rules for your specific state, which is why I keep saying the lease and the notice process you used in 2020 or 2021 needs to be reviewed right now by someone who knows current law in your market. Second, just because eviction laws are spreading and fast. This one is huge, and it is moving quickly across the country. Just cause eviction, sometimes called for cause eviction, means that as a landlord, you can no longer terminate a month-to-month tenancy simply because you want to. You have to have a legally recognized reason: non-payment of rent, lease violation, criminal activity, owner move-in, substantial renovation. Those are the typical acceptable reasons, depending on where you are. What you can no longer do in jurisdictions that have adopted just cause eviction is simply decide you don't want to renew someone's lease because you found a better tenant willing to pay more, or because you want to remodel the unit, or frankly, because you just want them out. If you can't point to a legally recognized reason, you cannot evict, period. Now, and this is important, just because eviction is not the law everywhere in the United States. It's still concentrated in certain states: California, Oregon, Washington, New Jersey, New York. These have been operating under some form of it for a while. But the list of cities and counties adopting local just cause ordinances has grown significantly. So even if your state doesn't have it at the state level, your city or county might. And local law governs. If you own rental property and you're not certain whether just cause applies to you, find out today, not tomorrow, today. Third, security deposit rules have been tightened across the board. The days of loosely holding onto a security deposit and handing back whatever you felt like at the end of a tenancy are over in most states. The requirements around security deposits have gotten stricter in multiple directions simultaneously. First, the cap. More states are limiting how much you can collect as a security deposit, in many cases down to 1 month's rent. If you've been collecting 2 months as standard practice, check whether that's still legal where you are. Second, the timeline. The window you have to return a deposit after a tenant moves out has been shortened in several states. Some are now as tight as 14 days. Miss that deadline, and in many jurisdictions, you forfeit your right to make any deductions at all, and you may owe the tenant penalties on top of returning the full deposit. Third, and this is the one landlords consistently get wrong, the itemization. You cannot just send back a partial deposit with a vague note. You need a detailed line-by-line written accounting of every deduction, supported by receipts or invoices where applicable. Normal wear and tear, carpet fading, small scuffs on walls, minor aging of fixtures, that is not deductible. Never was, but enforcement is getting stricter. A tenant who knows their rights can take you to small claims court over an improperly handled deposit and win not just the deposit back, but additional damages. Document everything at move-in. Document everything at move-out. Photos, video, written condition, reports signed by both parties. This is not optional anymore. Fourth, rent control and rent stabilization are expanding into new markets. This is probably the most politically charged issue on this list, and I'm going to stay out of the debate about whether it's good or bad policy. What I'm going to tell you is what's happening on the ground, because as a landlord, the political argument doesn't matter. The law is the law. Rent control, or its slightly more flexible cousin, rent stabilization, has been creeping into markets where landlords never expected to see it. We're not just talking about San Francisco and New York City anymore. Smaller cities, suburban markets, mid-sized metros, local governments under pressure from residents being priced out have been passing rent stabilization ordinances at a pace that would have seemed impossible 5 years ago. What this typically means in practice, you cannot raise rent beyond a certain percentage per year, usually tied to some version of inflation or fixed cap, often somewhere between 3 and 5%, depending on the jurisdiction. If your operating costs are rising faster than that cap, and in Florida especially, insurance and maintenance costs absolutely are, that's a problem you need to factor into your financial model. And here's what catches landlords off guard. Some of these ordinances have retroactive implications, meaning the unit you've owned for years and never had to think about this way is suddenly subject to new rules. Know your market. Know your local ordinances. Fifth, the eviction process itself has gotten significantly slower and more expensive. Even when you have a completely legitimate reason to evict, non-payment, lease violations, whatever it might be, the actual process of getting that tenant out has gotten more drawn out and more costly in most jurisdictions. Court backlogs built up during the pandemic moratorium era never fully cleared. Filing fees have gone up. In many areas, legal representation is now effectively required because the procedural requirements have become too complex to navigate reliably on your own. And a growing number of jurisdictions now have tenant legal aid programs, meaning your tenant may have access to free legal representation while you're paying an attorney by the hour. I'm not saying this to discourage anyone from owning rental property. I'm saying this because if your financial model assumes you can turn a non-paying unit around in 30 days, you need to update that assumption. In many markets, you should be planning for 60, 90, sometimes 120 days from first notice to actual possession, and budgeting for the legal costs that come with that timeline. This is exactly why tenant screening on the front end has never been more important. The cost of a bad tenant in 2026 is dramatically higher than it was 5 years ago. Spend the time and money on proper screening. Run credit. Run background. Check rental history. Call previous landlords and actually ask real questions. The hour you spend screening properly could save you months of headaches on the back end. Sixth, habitability standards and maintenance obligations have expanded. Landlords have always been required to maintain habitable conditions. Working heat, plumbing, no pest infestations, structural safety, that kind of thing. But what counts as a habitability violation has been expanding, and the consequences for failing to address issues promptly have gotten more serious. In an increasing number of states, tenants now have the right to withhold rent or repair and deduct, meaning they can hire someone to fix a habitability issue themselves and deduct the cost from rent, if a landlord fails to respond to maintenance requests within a specified time frame. That window is often shorter than landlords expect. Some states require a response within a week for urgent issues. Additionally, the documentation requirements have gone both directions. As a landlord, you need written records of every maintenance request and every action you took in response. Verbal communication is not your friend here. If a tenant texts you about a leak and you fix it, reply in writing, confirming you received the request and addressed it. Build that paper trail on every single issue, no matter how minor it seems. Because what used to be a maintenance dispute stays a maintenance dispute. What becomes a habitability lawsuit is a completely different animal, and the damages in those cases can get serious. Seventh, short-term rental regulations are tightening dramatically. If you own a property and you've been using it as an Airbnb or VRBO, or you're thinking about doing that, the regulatory environment has gotten dramatically more complicated in the past 2 years and is continuing to tighten. Cities and counties across the country have been cracking down. Permit requirements, owner occupancy requirements, meaning you have to actually live in the property to rent it short-term. Caps on the number of nights per year, neighborhood-level restrictions, HOA restrictions that have become more legally enforceable, and in some markets, outright bans in residential zones. Florida, in particular, has had a complicated and shifting relationship with short-term rental regulation. The state has historically preempted local governments from banning short-term rentals entirely. But that landscape has continued to evolve, and local enforcement mechanisms have gotten more aggressive even within that framework. If you're running a short-term rental operation, or planning to, you need to know the current rules in your specific jurisdiction. not the state level overview, the local ordinance. And you need to have that reviewed regularly because these rules are changing faster than almost any other area of landlord-tenant law right now. Eighth, tenant privacy protections are getting stronger. Landlord entry requirements have been a point of legal conflict for years, and states have been progressively strengthening tenant privacy protections around when and how a landlord can enter a rental unit. The standard notice requirement in most states is 24 hours. Some have moved to 48 hours. And the acceptable reasons for entry are becoming more defined and more limited. You cannot enter simply to check on the property or because you're curious about the condition. You need a legitimate reason. Repairs, inspections, showing to prospective tenants, and you need to provide proper advance notice. Entering without notice or entering under false pretenses has become a significant source of legal liability for landlords. In some states, unauthorized entry can be treated as harassment and can give a tenant grounds to break their lease without penalty and potentially sue for damages. If you've been casual about this, tighten it up immediately. Ninth, application fees and screening processes are under new scrutiny. Several states have passed laws limiting how much landlords can charge for rental applications, what information they can collect, and how they can use it. Credit checks, background checks, eviction history, all of these are still generally permissible, but the rules around them are becoming more specific. Some jurisdictions now have source of income protections, meaning you cannot reject an applicant solely because they pay rent with a housing voucher rather than a traditional paycheck. If you've been screening out Section 8 or other voucher holders as a blanket policy, that practice may now be illegal where you operate. Criminal history screening has also come under scrutiny. Blanket policies rejecting anyone with any criminal record have been challenged successfully in multiple courts. Many jurisdictions now require individualized assessment, looking at the nature of the offense, how long ago it occurred, and its relevance to tenancy, rather than automatic disqualification. This doesn't mean you can't screen. It means your screening process needs to be consistent, documented, and defensible. Apply the same criteria to every applicant. Document why each decision was made. If your process is challenged, you need to be able to show that you applied the rules equally. And here's the bottom line. The landlord-tenant relationship in 2026 is more legally complex than it has ever been. The margin for error for landlords and tenants has shrunk. The cost of getting it wrong has gone up on both sides. If you're a landlord and your lease agreement, your screening process, your notice procedures, and your deposit handling haven't been reviewed by someone who knows current law in your specific state and municipality, that is the single most important thing you can do for your rental business right now, not next quarter. Now, if you're a tenant and you feel like you've been treated unfairly, deposit withheld without proper accounting, evicted without proper notice, maintenance requests ignored, you likely have more legal recourse than you realize. Tenant legal aid organizations exist in most major cities and many smaller markets too. Know what you're entitled to. The rules changed. Make sure you change with them. If this broke things down in a way that actually made sense to you, subscribe. Because I cover this stuff regularly and the laws are going to keep evolving. And if you want to go deeper on any one of these topics, I've got dedicated videos on eviction procedure, security deposit disputes, and lease agreements right here on the channel. Go check those out, and I'll see you in the next one.